Good afternoon, everybody, and thank you for joining us for the final webinar in Conn Maciel Carey's 2016 OSHA webinar series. We've had a really enjoyable time over the course of the year covering some very interesting OSHA issues and, where applicable, combining the two specialty practices of Conn Maciel Carey and doing a OSHA and employment law hybrid presentation, and we get the opportunity to do that once more here in our final webinar. Today we'll be talking about bathroom issues as they intersect with OSHA regulatory issues and employment law issues. And we thought this would be kind of an interesting topic to end the year. It's been one of those years that maybe you're ready to flush down the toilet, and so appropriate here that we're going to have a little bathroom break and talk about OSHA and employment issues related to bathrooms. So let me give you a little bit of background about who are these faceless voices that you're hearing today. My name is Eric Conn. I'm one of the founding partners at Conn Maciel Carey, and I chair the firm's National OSHA Workplace Safety Practice Group. I focus my practice exclusively on all aspects of occupational safety and health law. I work with employers during inspections and investigations by the alphabet soup of agencies that look into incidents like that, OSHA primarily, the state OSHA programs, the Chemical Safety Board, and other agencies. I also handle the full range of OSHA-related litigation, including criminal investigations and prosecutions, civil citations, appeals of civil citations, and then I consult with personal injury and wrongful death counsel on the applicable OSHA issues to those types of cases as well. I'm joined today by my partner from our labor and employment practice, Jordan Schwartz. I'll let him introduce himself, and then we'll get into our subject matter.
Thank you very much, Eric, and it's nice to join everyone here on this last presentation of 2016. I am a partner in the labor and employment practice here at Conn Maciel Carey, and I basically represent employers in all aspects of employment-related litigation. Some of the things we'll be discussing today from my vantage point will be some ADA accessibility issues, which is one of the things I do a lot. I go to various companies and perform inspections and try to help you figure out before a potential plaintiff figures out what is or is not accessible at your company and what might need to be changed if you are open to the public. And in addition to performing on-site investigations about disability issues, I perform a lot of on-site investigations about wage and hour issues to make sure employers are paying their employees the proper way, and again, with the mindset of me finding any issues before a potential plaintiff or state or federal agency discover any issues. And in addition to disability and wage and hour, certainly other issues like we'll be discussing today, discrimination and harassment based on all sorts of protected characteristics, including some transgender issues that related to bathrooms that we'll be discussing today. And I basically just counsel employers on all sorts of ways to comply with the litany of federal and state laws that can be quite confusing. And finally, I do advise on union-related issues and provide advice on employers' rights and how to best interact with unions under the National Labor Relations Act. For now, I'm going to turn the first part of the presentation back over to Eric.
All right, thanks. So, yeah, I mean, Jordan mentioned the transgender bathroom issue, and that is one that, has been, regardless of your feelings about it, regardless of your politics, has been sort of a fascinating glimpse into government. We are often talking about, government intrusion into places where the government may not belong, government overreach into areas that may not make sense for the mandate that agency has been given by Congress, and this area is certainly one. The idea that OSHA has inserted itself into, bathroom issues generally, transgender issues more specifically, did not seem intuitive to me as someone who practices in the area of OSHA extensively. And so when this issue became a hot issue nationally, with all the fallout from the North Carolina bathroom law and other states that have followed suit, and then OSHA really inserting itself into this process, that was sort of our inspiration for doing this webinar, is to try and understand how it is or why it is and in what ways government believes that it has a role either in regulating to mandate accommodation of transgender bathroom issues, or to regulate and try and eliminate the accommodation of gender identity bathroom issues. So we'll approach that particular issue spans both Jordan's and my practices. We will talk about the transgender bathroom issue from an OSHA perspective and from an employment law perspective as well. But that's not all we're going to talk about today. There is, in fact, quite a number of ways that OSHA has inserted itself into the regulation of bathrooms and workplaces, and there's other ways that the Department of Labor and private plaintiffs on the employment side, or generally the civil liability side, have inserted themselves into the design and functionality of bathrooms in workplaces and places of public accommodation, and we're going to cover all of that today. So we're going to start off from the OSHA perspective, and I can't tell you how much joy it gave me to put together a graphic for a webinar, finally, where I got to put OSHA's logo on a toilet. I've been trying to find that excuse for years, and so finally we were able to do that. So we'll start off the discussion today talking about employee access to sanitary bathrooms, and that's really a combination of two issues. It's accessibility, prompt accessibility to a bathroom, and when you do access a bathroom, that bathroom should be in a sanitary condition. And these are important issues. It was never really intuitive to me why it was an important OSHA issue. Why is OSHA inserting itself at all into bathroom issues? And the concept is that OSHA draws a link, and medical professionals draw a link to some serious health-related consequences for not having ready access to a bathroom, and then sort of a more obvious link to the health consequences of not having a sanitary bathroom to use in the workplace or really anywhere, but OSHA's role is only to insert itself into work-related issues. So OSHA, through very specific regulations, this is not a general duty clause issue, this is not an amorphous issue, OSHA has specific regulations on ready accessibility to bathrooms in workplaces, and that your bathroom should be sanitary. And it's these two different concepts that really overlap in a lot of ways, but OSHA requires employers to provide all workers with sanitary and immediately available toilet facilities. The sanitation rules are intended to ensure that workers do not suffer adverse health effects of either not being able to get to a bathroom promptly when they need it, or that the bathroom that they are provided is not sanitary. And there's multiple forms of health consequences to that. The idea that one is not available to you promptly has health consequences like urinary tract infections that can translate into more serious infections, abdominal pains, diverticulitis, constipation, and all sorts of things that my mother would be horrified that I was talking about to a large group of people. But those are the things apparently that OSHA is focused on right now. And so let's dive into a little bit about that accessibility and sanitation concept. OSHA's view is that toilet facilities must be provided and available to all employees at fixed work sites. And we will talk separately about mobile crews and unattended, ordinarily unattended work locations. But for the initial discussion here, we're talking about those fixed work locations where employees are, on a day-to-day basis there to perform work activities. You must provide ready, accessible, sanitary bathrooms in those work establishments. And what OSHA means by readily accessible or available is the term in the regulation, is that a toilet that takes too long to get to is not available. So if it is some place that you have to walk a quarter of a mile to get to the bathroom, OSHA may not consider that available. And there are not specific standards. The standard is not specific as to proximity. This is a performance-based standard, and based on the configuration of your workplace and the locations where your employees may be, and how accessible different parts of the workplace are, a bathroom needs to be in a location that does not take too long to get to. And OSHA has been clear that there's not a requirement to have a bathroom on every floor of your workplace, but it does need to be available. A toilet that has too long of a line, and really that's about capacity. If you have too many employees waiting to use or designated or assigned to use a particular bathroom, which will result at break times or pre and post shift times, would result in too long of a line where an employee has to wait an unreasonable amount of time to access the bathroom, that would not be considered available from OSHA's perspective under the sanitation standards. And then finally, a toilet facility that is not sanitary, even if you have 100 of them and they're, you never have to walk more than 10 steps to get to one. If they're not sanitary, then that's not considered by OSHA to have a sanitary, readily accessible bathroom available to employees. And from a sanitation standpoint, again, a pretty vague concept that is not detailed in the OSHA standards, but there is some guidance out there that OSHA directly cross-references, and there's an ANSI industry consensus standard. And what that standard addresses, still in sort of an amorphous way, is how often you ought to be cleaning the bathroom. So it's not really about a particular level of cleanliness, and there's not an easy way to quantify that, but the standard is there to say, depending on the frequency of use, the number of employees who might on a day-to-day basis be using that bathroom, the ANSI standard would reflect on how often, in ordinary circumstances, you should be maintaining that bathroom, how often you should be cleaning it, how often you should be restocking it. And again, it's not black and white. It is sort of it's guidance to suggest that, in ordinary circumstances, a bathroom that is being expected to be used by 20 people ought to be serviced twice per week. And again, that depends on, are you a 24-hour work operation, and how heavy and impactful is the use when it's being used, would also affect OSHA's view of whether it's sanitary. And this is one of these situations where there is a standard, and OSHA cites a specific standard, but it's almost got that general duty clause type of feel to it. I can't recall ever seeing a sanitation citation that did not arise out of an employee complaint. So it's one of these sort of subjective things where if an employee says, hey, I don't think that I've been being provided a sanitary bathroom, OSHA is much more likely to take the view that you've not met the requirements of the standard. On a run-of-the-mill programmed inspection, it's unlikely that OSHA is going to go into the bathroom unless it's for personal use, and even if they do, unlikely that they're going to use this standard against you unless an employee or a union or somebody is motivating OSHA to do that. The other area from a sanitation standpoint is not just about having a clean restroom facility, it's about having a stocked restroom facility, and that's primarily focused on the hand washing supplies and clean, dry towels to use after hand washing. But I have seen OSHA raise a concern that toilet tissue is not available, and that raises sanitation concerns and health concerns for employees. And so we've seen citations in that regard as well. But that's the general issue that OSHA is focused on availability and accessibility. That concept of having to wait in line too long, there is actually some fairly specific guidance. I want to say not guidance. This is actually spelled out in OSHA's standard, an expectation of the number of bathrooms that will be provided based on the size of your workforce. And the different standards, general industry standard, the construction standard, the agriculture standard, all have a different breakdown of the expected number of toilet facilities that would be available to workers. And it's based on the number of employees and the gender of employees. And we'll talk about later this gender identity question, but for the moment, let's just talk about sort of the traditional gender identity concept, that you've got 20 male employees and 20 female employees. How many bathrooms that are available to those specific genders do you need to have in your workplace? And the idea in the OSHA standard is that you must provide at least the minimum number of toilet facilities according to this table that we've plucked right out of the standard, specific number built into the standard, in rooms separate for each gender. So you have two options. You can have gender-specific bathrooms, or you can have separate toilet rooms that are available, that are unisex, basically, that any gender can use it, as long as they are lockable and single-occupant toilet facilities. So if you have separate toilet facilities that are lockable and gender neutral, you don't have to do a breakdown by the number of employees of certain genders, but you still have to have the right number of toilet facilities based on the number of employees. So if you have 50 employees regardless of gender, and you're going to accommodate that by having unisex, individually lockable toilet facilities, you're required to have, by the OSHA standard, at least 3 of those types of toilet facilities. If you have gender-specific toilet facilities, you have to do the analysis, the employee count, based on the number of employees of each gender. So if you have 20 each, 20 male employees, 20 female employees, you'll then need to have 4 bathrooms, or 4 toilet facilities, 2 each for each gender. And then if you have a very large workplace, over 150 employees, you get up to that a minimum of 6 toilet facilities per gender, or 6 total if they're separately lockable, gender neutral. And if you get over 150, you add one more. You're required to have at least one more toilet facility per each additional 40 workers. There's a great question has already been asked about the need for potable water for hand washing and or toilet flushing, and is there a potability requirement? There is absolutely a requirement in fixed workplaces to have plumbed, clean, sanitary water for hand washing, and there is sort of a separate requirement outside of this context for potable drinking water. And now some states and federal OSHA have a big focus on heat illness issues. So requirements to have cool, fresh drinking water are required under the General Duty Clause or certain state laws for those types of workplaces as well. The construction bathroom regulation is modeled very similarly after the general industry regulation we just talked about, except the number of facilities that you're required to have, it's a little bit less per employee. And then there's also an exception. I should go back. In the general industry rule, if you have a fixed workplace, there's a requirement that your toilets are plumbed, that they are connected to a sewer system, and that this is a plumbed, fixed, stationary, proper bathroom facility. In the construction setting, obviously that's not feasible, or often is not feasible, so you are permitted to, and generally do, meet the requirements of this standard by providing at least the minimum number of required facilities of these types, an outhouse, a porta potty, and some of these other types of portable, non-plumbed, non-permanent bathroom facilities. A couple of other kind of interesting accessibility, giving employees access to the bathroom facility issues that OSHA has regulated and from time to time does enforce, is in terms of having a bathroom that is readily available to an employee is not just about the physical presence of the bathroom, it's also about the employee's ability and authority to go use the bathroom when he needs to. And so OSHA takes a very hard look at any restrictions that an employer places on access to a toilet. For example, if you have locked restrooms and employees need to go and request a key from a supervisor, or even to just go required to ask permission to use a toilet during the work shift or while at work. Those types of restrictions must be reasonable, and they must not cause any extended delay, the type of delay that might have a negative health consequence on an employee. So OSHA is not saying you're not permitted to have a locked bathroom, and you're not permitted to have employees ask permission, but if you do have those types of restrictions, that they must be reasonable and they must not cause undue delay. The area where we see, this issue come up most often, where an employee needs permission to use the toilet, is in the context of an assembly line type of work function or some other type of work activity where one employee stopping the performance of his particular work duty causes a disruption, shuts down the assembly line process, shuts down some operation process that can't proceed while that employee is doing his job. Take, for example, a hole watch for a confined space entry. If the hole watch needs to use the restroom, that disrupts the activity because the entrant can no longer be inside the confined space and performing the work. So anything where an employee's absence would be disruptive, how do you deal with that from a accessibility and permission standpoint? OSHA's view of that is that, a couple things you can do. One is provide sufficient relief workers so that if someone needs to beg off to go to the bathroom, they don't have to wait for a relief worker to come in so long that they have a negative health consequence. Or you just stop the work activity. If you can't get a relief person in place to allow the operation to continue, and it's getting to that extended delay, that unreasonable delay, then you just have to stop the work activity from OSHA's perspective, or you've violated this law. A last issue on this I'm going to let Jordan talk about briefly is the Americans with Disabilities Act in the employment context, how that ties in with this accessibility issue.
Thanks, Eric. And yeah, for ADA issues involved in this, you have to think of two things. One, almost anything these days is considered a disability. Certainly if someone's pregnant, but really if someone has to use the bathroom a lot, that's probably going to be a disability, regardless if they might have irritable bowel syndrome or some other bladder control or prostate issues. That's going to be considered a disability. So because of that, as an employer, your obligation is to engage in reasonable accommodations for that disability. And that doesn't mean you have to allow anything under the sun, but that means you actually have to have a discussion and consider allowing whatever it is that is requested. It might be just allowing an individual to use the bathroom as much as he or she needs during that either temporary time or longer than a temporary time. If an employee is located quite far from a bathroom, a reasonable accommodation might be to switch the employee's location so they are much closer, so they're not wasting so much time going on the walk to and from the bathroom. But really, as the slide says, you just really need to consider all the issues associated with bathroom access and think about what may or may not be considered reasonable. Maybe an employee will ask to sit closer, and you'll decide that's not reasonable because that'll take that employee away from his or her team, and it will be more of a disruption. But if you decide that, you have to make sure to try to figure out any other potentially reasonable alternatives to alleviate any uncomfortable situation of an employee claiming that he or she was prohibited from using the bathroom.
All right, so we've covered sort of the bathroom requirements, accessibility requirements at the fixed work establishment and the regularly attended work establishment. There is a different set of requirements that relates to mobile crews and unattended work locations, regularly unattended work locations. From the standpoint of mobile crews, obviously there is not a reasonable bathroom facility if someone's job has them in a motor vehicle moving around the city, moving around the town on a regular basis. But because that employee is essentially mobile and in a vehicle, most likely a company vehicle, but that's not a requirement, if they have ready access to a means of transportation, transportation is immediately available to them, and they can get to some nearby sanitary toilet facility. And that would include all of the places of public accommodation out there that have toilet facilities, restaurants, convenience stores, gas stations, things like that, that you do not have to supply a restroom facility in the same manner that you do at a fixed work location. And that's true also of normally unattended work locations. There's not a requirement to supply a bathroom facility at a normally unattended work location, like a natural gas well site that employees might go and pick up, gauge tanks or fill up a transport vehicle to take gas or oil or whatever from that location. If it's not normally attended, and those employees obviously to get there have immediately available transportation methods, you're not required to supply a bathroom facility at that location. But you are required to ensure that there is a nearby sanitary toilet facility. And what does nearby mean? This is not defined. It's not black and white. OSHA has stated in some interpretation letters and some guidance that the expectation is that they will have prompt access through the transportation method that they have, their truck, their car, whatever it is, that they can get to a sanitary toilet facility generally in about 10 minutes. That is, again, not a black and white number, and there are certainly circumstances where that's not feasible. When you talk about these remote, gas well sites, oil well sites, where there may not be a gas station in a 10-minute range, we have addressed that issue, dealt with that issue with OSHA before, and basically demonstrated that there's not a feasibility. It's not feasible to have something within a 10-minute period, but we do have transportation immediately available. And one of the things we did to satisfy OSHA is that we communicated to employees those locations that we were aware of where there was a great distance between the nearest gas station and that remote work location, so they can make some decisions in advance of their travel, whether they needed to go to the bathroom first, like our moms always told us before a long car trip. So that seemed to satisfy OSHA in those cases, that they recognize the feasibility or the lack of feasibility of providing a toilet facility in a place that is rarely visited, but is also quite remote. So this is really just a reasonableness standard. Feasibility factors into it as well. So in addition to the idea of providing toilet facilities and sanitary toilet facilities, we brainstormed a little bit about what are the other ways that OSHA and OSHA regulations and OSHA requirements interact with and have some connection to bathrooms. And we just thought it would be interesting to talk about the different ways and the different scenarios where you need to think about the bathroom in the context of OSHA. And one real obvious one that jumped to our minds is there's all these chemical-specific standards out there that if you have reasonably anticipated occupational exposures, and it's foreseeable that those occupational exposures may exceed an action level or a permissible exposure level, that you need to provide certain types of bathroom facilities. And now we're not talking about toilets anymore. We're talking kind of about the locker room arrangement that you've got to have in a lot of these workplace where you're dealing with lead and there are serious potential lead exposures or asbestos exposures. The chemicals that we've identified here, where there is a chemical specific regulatory set of requirements that include bathroom facilities. And in those circumstances, there's a requirement to provide a shower for employees to sort of move from the work floor with their potentially contaminated work clothes, remove their contaminated work clothes and deposit them for some professional cleaning, and then move from that sort of dirty side into a shower facility, do a personal decontamination, and then move from there into a clean side where you are required to provide storage facilities for your clean street work clothes so that you're not taking contaminated chemical exposures home with you to get into your kitchen and to expose you and your families. So under these chemical-specific standards, there are some pretty detailed bathroom-related requirements, and here's what they are: sort of the number of shower facilities you're required to have based on the number of employees of each gender, and certain types of cleaning agents that you must have available there. The shower facilities under these chemical standards, there's a requirement that hot and cold would be fed through a common discharge, so it's not, hot water coming from one location, a cold hose over at the right. It's a proper shower configuration, and that you've got to have clean sanitary towels available as you move from the shower, from the dirty side through the shower into the clean side of the changing room, and then the changing room that we talked about. One last issue from a sort of generic OSHA standpoint, where does OSHA find itself regulating bathroom-related issues, is on the janitorial front. Aside from the fact that, we've talked about the requirement to maintain a sanitary bathroom, so you've got to engage that janitorial service to make sure you're providing a sanitary bathroom for your employees. You also need to think about the individuals, if they are your own employees as opposed to an outside service, who is actually performing the janitorial service in the bathroom. There are hazards, unique hazards, that those employees may be exposed to by virtue of the fact that they are performing a janitorial service in the bathroom. And here's the three things that we thought of that were relevant in that regard. One is, you have to perform a PPE hazard assessment for all of the work locations and work activities at your establishment to identify hazards that employees may be exposed to. And if you have your own employees engaged in janitorial services, and in particular janitorial services in the bathroom, you should at least be doing an assessment of potential unique hazards that they may be exposed to, which may require the use of some specific personal protective equipment, like protective gloves, like protective eyewear for splashes, and if you're using cleaning chemicals or just cleaning around the unsanitary human waste, if there's a risk that gets on your skin or gets in your eyes, there's health consequences to that. So you should be thinking about that as you're performing your PPE hazard assessment, and think about that particular task, cleaning the bathroom. Are there unique hazards that require the use of PPE, and if so, provide that appropriate PPE. Bloodborne pathogens is another issue that I thought about in the context of a janitorial service in the restroom. If there is potential exposure or reasonably anticipated occupational exposure, which I think for your janitorial staff there probably is, exposure to infectious or potentially infectious blood or other potentially infectious bodily fluids. And the individual who's cleaning the toilets, I think, has that potential exposure. And certainly if there's any risk, and if you've got any history with needles being identified in bathrooms as they're being cleaned, either from a health standpoint, a diabetic who is using and disposing of needles in the workplace, or heaven forbid there's a drug use in the workplace, either by employees or more likely, you hope, from the public. If you operate a C-store, a gas station, and the public comes into the workplace and uses hypodermic needles for whatever reason, and they are found on some non-inconsequential frequency in the bathroom, and your employee is required to clean it up as opposed to using a third-party vendor, the bloodborne pathogen standard may well apply to that employee. And you need to do an assessment under the bloodborne pathogen standard to identify those work activities for which potential exposures exist, and for which you need to implement an exposure control plan, provide the appropriate PPE and training, and then post-exposure follow-up. So that's another issue where, in kind of an interesting way, the bathroom might sneak up and introduce additional requirements that perhaps we haven't thought about historically. And then the last thing we thought about is hazard communication. It may be that you have a workplace that is essentially void of hazardous chemicals, except for cleaning agents that may be used by your janitorial staff in the bathroom. And so everybody pays attention to our operating processes and the chemicals that we use in the process of conducting, whatever manufacturing process or construction process or whatever it is. But maybe we're not thinking about the cleaning chemicals that are used in our bathrooms. And maybe those are the only chemicals in the entire workplace. And we've thought, hey, we don't have to have a written hazard communication program because we don't have hazardous chemicals, and we don't have to have, training for employees or hazard category training or maintain SDSs because we don't have chemicals in the workplace. But lo and behold, you have a hazardous chemical that is used regularly to clean your bathroom facility by your own employees. If that's the case, then you do have to have a HazCom program. You do have to provide category training on whatever type of hazard is presented by that chemical, whether it's a corrosive, toxicity, whatever it is, and maintain the SDS for that cleaning chemical and the list of chemicals that you have in the workplace. It needs to be on that list. So these are things that perhaps we haven't thought about historically, where OSHA issues might arise because of our bathrooms that we thought were worth talking about. And then we moved to the area where, until I read this memo, I never would have believed that OSHA had a role in dealing with the transgender issue. And frankly, I'm not sure that they really do from a legitimate workplace safety and health standpoint. But it was not terribly surprising to see under the Obama administration the Department of Labor, finding unique and creative ways to advance their, pro-LGBTQ agenda. And they've done that obviously historically through things that Jordan will talk about through EEOC and certainly Title VII addressing sex discrimination and extending that, I believe, and Jordan will talk about it, to gender identity issues, sexuality issues, things like that. So I sort of always saw this, and I think most people generally saw this as an employment issue, a Title VII issue, an EEOC issue, maybe a retaliation issue, but not as an OSHA issue. But, the administration is looking for ways to advance its agenda. They try to find it in places that, we might not think are the most obvious places to look. And OSHA found a way to insert itself into this issue and to try to advance the Obama administration's agenda on this issue. And they did it in kind of an interesting and creative way. They issued guidance, which I would have expected to see, from the Department of Labor, but not necessarily from OSHA, basically pushing the gender identity bathroom issue in workplaces as a way to sort of make it more mainstream and perhaps to make it, the norm in workplaces and non-workplace public accommodations alike. And what they did was they said, look, we have always had this requirement. We have always had this regulation that requires employers to provide ready access to bathrooms. And the purpose of that and the health purpose of that is that if you don't have access to a bathroom, or if you have to wait a very long time to use the bathroom, or if the bathroom arrangement is so unappealing because it's unsanitary or whatever reason that you don't use it, or you can't use it, or you have to wait a long time to use it, or you're not comfortable using it at work at all, and then wait an entire work shift to go home to use the bathroom, that there are those health effects that we talked about before. That by holding it, there is risks of infections. There is risks of serious stomach and digestive problems by not being able to use a restroom when you need to use a restroom. And OSHA took the leap from that point of saying this has traditionally meant physical access to a bathroom, that a bathroom exists and it is clean, a leap from that to say if you do not provide a bathroom that aligns with an employee's gender identity, then that employee may feel unsafe using the other bathroom. If an employee feels that they identify as a female, but they are required at work to use the male bathroom or the men's room, that worker may feel unsafe going into the men's room, may feel that they could be attacked or assaulted or alienated, or otherwise just feel so uncomfortable using a bathroom of a gender and with others of a gender with whom they do not identify, they will restrain or basically restrict themselves from using the bathroom at work. And by doing that, it creates this health risk from OSHA's perspective, the same as it would as if there was no bathroom at all. If you're not comfortable using it, it's essentially the same in OSHA's mind as the bathroom not existing, and therefore you have to hold it, and if you hold it, those health risks exist. So OSHA, in this guidance document that they developed in connection with the transgender bathroom guidance, they introduced some model practices, some sort of do's and don'ts for how to address and how to ensure accessibility to a bathroom facility for all of your workers, regardless of their gender identity. That you should have a written policy that expresses to all of your employees your commitment to provide and your actual steps that you're taking to provide all employees with prompt access to appropriate sanitary facilities. And appropriate here is where OSHA's saying that we've got either men's room, women's room, and gender neutral rooms, or just a host of gender neutral rooms so that all employees have access to a toilet facility that they're comfortable using. And they recommend specifically for how you engineer that, how you deal with that issue, is that you provide a series of single occupancy unisex toilet facilities, or a larger multi-occupant bathroom that has gender neutral lockable individual occupant stalls. Those are two solutions to this issue that OSHA has identified. Other things that in this guidance they make clear that you should not be doing and that your policies should not include would be being sure to not ask employees for medical records or legal records to validate or confirm whatever gender identity issue the employee is raising. To say, okay, well, if you believe that you should be using, you identify yourself with the female gender. I don't see it that way as the employer. I need to see a note from your doctor that confirms that. OSHA is saying that would be an unlawful intrusion, and I'm sure in Jordan's discussion he'll talk about some of the employment implications of asking for those types of what were probably considered to be medical, private medical documentation. It's just not something OSHA is saying that you should be asking, and if you do, they would try to find a way to have an enforcement consequence for that. Either viewing it as a restriction to the bathroom by asking those private questions is effectively the same as restricting access, so citing under the sanitation standard, or more likely pursuing the case under Section 11C as a retaliation claim and saying that you've provided, you've retaliated against the employee for raising a health issue because OSHA perceives this as a health-related issue. And then the other thing that OSHA says that you should not be doing as part of its best practices here is, sort of keeping the status quo with a men's room and a women's room, but if you are transgender, go use this bathroom around the corner, down the hall, up 3 flights of stairs in the corner of the building that is different and segregated from everyone else's bathroom access, because that will make the employee feel alienated and, again, perhaps unlikely or unwilling to use the restroom at work, causing these health issues. So that's where OSHA has gone down that path there. I talked a little bit about how any of this might be enforceable from an OSHA standpoint. I just mentioned the idea that if there is, OSHA perceives that there is not a bathroom readily available to a transgender employee, they would view that as a, just traditional violation of the requirements under 141, 1910-141 for providing readily accessible sanitary bathrooms. And then the other issue, and OSHA raises this in the guidance document, that there's this concept of feeling unsafe, that if you don't provide appropriate, gender identify, a bathroom for an employee in the gender that they identify with, that there is this feeling that they would be at risk of assault and they would feel unsafe. And OSHA has pretty consistently been enforcing workplace violence-related issues, and I think that's how OSHA would perceive this under the General Duty Clause. And then, as I mentioned, retaliation complaints under Section 11C. I could easily see OSHA saying the employee raised a safety and health concern, accessibility to a bathroom, and you engaged in an adverse employment action, either by not allowing them to have a bathroom that they feel is appropriate for their use, or for requiring them to use some far-flung bathroom that is not consistent with others' employees' use, or taking some actual adverse employment action, a termination, a suspension, or something like that for not going along with the arrangement that the employer has set in place, that there can be retaliatory consequences. So injunctive relief, back pay, things like that may be available. So I'll turn it over to Jordan now, and he'll sort of pick up the trend of this transgender issue from the employment context, and then move into other employment law issues that arise related to bathrooms.
Well, thank you very much, Eric. Eric took up some of my time, as he tends to do, but so I don't want to keep you guys too far over, but I'll be sure to hit all the highlights here about the transgender issues, and then some other relevant employment-related bathroom issues. First of all, with the transgender workplace obligations, Eric mentioned this a little bit, and I don't want to go too deep into the legal background, but just to help you understand where this comes from, there was a famous case about 20 years ago called Price Waterhouse versus Hopkins, and in that case, a senior manager of an accounting firm, she was denied partnership mainly because she was considered macho and she wasn't feminine enough, and the powers that be at the firm just didn't really like her demeanor as a female. And the Supreme Court found that was certainly a gender discrimination, the way they stereotyped her and denied her a promotion based on what they perceived was her sex. And that really formed the basis of how the U.S. courts look at sex discrimination. And later on, this has been used as a precedent to determine that men have been discriminated against for wearing dresses or acting femininely. So really, anytime you're acting in a way that's perceived as different than you should act, the Supreme Court has found that to be a form of sex discrimination. And now, in the past few years, with all these gender identity issues, the law is now being interpreted to have gender include gender identity, self-image, appearance, behavior, and expression. And the EEOC has been really clear that Title VII prohibits discrimination based on this gender identity, similar to how the courts perceived it, as I just explained. The U.S. Attorney General issued an official memorandum that Title VII is specifically banning discrimination because an employee is transitioning or has transitioned either from a male to a female or a female to a male. So that's really the genesis for why and how transgender obligations have been able to fit kind of so neatly into sex-based obligations under legal precedent. And now it's basically been pretty uniform through federal agencies, at least, and that certainly is different in states. But from the federal vantage point, the Equal Employment Opportunity Commission, the Department of Justice, the Department of Labor, have all been pretty clear in interpreting prohibitions in Title VII to include discrimination based on gender identity or transgender status. In about a year ago, the EEOC ruled specifically that an employee cannot be denied access to common restrooms used by employees of the same gender identity. The Colorado, Delaware, Iowa, Vermont, Washington State, and also District of Columbia have employment laws, and other states do as well, similar to these federal laws that really require employers to allow employees access to restrooms in accordance with their gender identity rather than their assigned sex at birth. And that's where Eric mentioned a little while ago. As an employer, you really can't say, oh, let me look at your birth certificate. Let me see what you were at birth, and that is how I want to limit the restroom to which you are able to use now. Again, there are some states that are nowhere near as stringent as others, and if you operate in one of those states, you still need to be careful, but you may not need to operate quite so stringently. But just know that from a federal agency perspective, or if you're in at least one of these states delineated in this slide, you really not only can't deny access, don't even really want to ask too many questions about any medical documentation or anything of that nature. So with that background, what do you want to do to minimize your potential liability? The first thing, and this is the case in so many different employment aspects of the law, is amend your non-discrimination and anti-harassment policies. A big part of my practice is to review employee handbooks, and quite often the employee handbooks certainly say you can't discriminate based on sex, national origin, age, race, but they don't specifically include gender identity and conformity with gender-based preferences. And it is, at this point, very important that your policies, internal, and if you have any external, if they're going to employees, if they're ever being shown to the DOL or any type of investigation, that they include gender identity policies. And I'm always happy to show samples if anyone ever needs help with that. Another interesting thing you want to consider, and again, these aren't things you have to do, but things you want to consider, is based on your company, and we have representatives from so many different industries right now, but based on your company, do you want to change some gender-based dress codes that you may currently have in place? Also, you might want to think about establishing any gender transition protocols. If this has happened at your workplace already, or if you anticipate it happening, you always want to have clear expectations so management can help a transitioning employee, both that employee and other employees who are witnessing this, really go through that transition as smoothly as possible. Obviously, personnel records will have to be revised, and all sorts of other employment-based documents that exist will have to be transitioned and changed, and you want to make sure you have practices in place to be able to do that the best way you can. Another thing you also want to do is educate and or train your workforce about transgender issues. I know here at our firm we go to our clients and provide training. Other companies do the same thing, and while you're doing maybe your annual discrimination or harassment training, it would be a good idea to actually have other training about transgender issues. Another bullet I have here is update restroom and locker room access policies. Eric spent a long time talking about bathrooms. I've talked about bathrooms, and I've given a lot of presentations, and I work with clients who say, oh, that's interesting. You've talked about bathrooms, and obviously everything you're saying doesn't apply to locker rooms, right? It's a whole different ballgame there. And what I usually have to explain is, no, it's pretty much the exact same rules. You know, you might assume, oh, we're at some, my company is a club, and people are going to be uncomfortable, if people are changing and spending time in a locker room. But the fact that some people might be uncomfortable doesn't really have any relevance to the law, at least from an employment practice, and I don't believe from an OSHA perspective either. So you really need to ensure that your the access to facilities is in accordance with, as I said earlier, the gender identification, and not necessarily the way someone was born. Also, be sure to use preferred names, and try to maybe, if possible, even if it has to be gender neutral, but try not to refer to someone who has transitioned by their former gender pronouns, because that is not going to make that individual happy, and that could lead to potential liability for lawsuits. I'm not going to talk too much in detail. I have about 3 or 4 cases that I described, but this first one has really been the most prevalent case that the past few years, if you've been following these transgender issues. And this is with the ACLU suing a school board in Virginia, where the school board has basically told a student that they weren't allowed to use the bathroom that they wanted to use, and they were able to get another bathroom, a segregated bathroom for that student. And the ACLU filed a federal discrimination complaint with the DOJ and the Department of Education, and they sought a preliminary injunction asking the court to rule in time for this individual to be able to use the same restroom as the other boys at his high school. At that time, the district court denied the injunction and dismissed this individual's claim. However, that decision was appealed, and the higher court in that area in Virginia, the Court of Appeals for the Fourth Circuit, overturned the lower court's decision just a few months ago. It was in August of 2016. And there's now a petition for the Supreme Court to review it. And then just a few weeks ago, about a month ago, the Supreme Court announced it will review this decision. So this will be a really interesting decision to come about, especially with a new administration that may not be as friendly to these policies as in the past. But the Supreme Court, as it's currently made up, will be, or however it's made up when they actually hear this decision, will have a really, really strong say in what types of obligations an employer will have when here it was a student, but for most of the people on this call, when an employee wants to use the bathroom that corresponds to the gender that he or she is choosing. A few other cases here. As I said, I'm not going to describe too much, but just know that this company, Deluxe Financial Services Corporation, was forced to pay about $115,000 after a similar suit where an employee transitioned from one sex to another and then was ostracized. Coworkers made hurtful statements, and what I mentioned earlier, people intentionally use the wrong gender pronouns, and that's why you want to avoid that sort of thing. Coworkers intentionally used the wrong gender pronouns, and all of a sudden the company was paying over $100,000 to have to settle the case. They also had to adopt an LGBT strategic enforcement plan. So these are just issues you really want to be careful of going forward. Right now, there's a case going on against Barnes & Noble. That's another significant case where someone was fired after undergoing panic attacks due to these transgender type issues. There's also a case going on in New York right now where actually the labor union is being sued because the individual claimed that the labor union did not protect his rights in the manner that he believed they should have based on transgender issues. And finally, I want to move off of transgender issues here for a few minutes and just talk about ADA accessibility issues as they relate to bathrooms. And just as a real quick background here, Title III of the ADA protects individuals in places of public accommodation. And those are places that are open to the general public. So some of the people on this call I know work at hotels, at schools, at theaters, at retail stores, at grocery stores. Any of those places are places of public accommodation. And under this part of the Americans with Disabilities Act, which is called Title III, no individual may be discriminated against on the basis of the disability in any public accommodation, or by any person who owns, leases to, or operates a place of public accommodation. So basically, an individual with a disability, and even an individual associated with a individual with a disability. So if you're a helper, or if someone's a helper, they are also protected. And an individual, as an employer, your obligation is to make goods and services available to individuals with disabilities on an equal basis with the general public, make goods and services usable by people with disabilities, and require the removal of any barriers in existing facilities. And now I want to tie that in with bathrooms. Obviously, if you operate a place of public facility, I'm assuming you have a bathroom in your facility. And there are a whole host of bathroom-related issues. Every single complaint I've ever seen regarding Title III of the Americans with Disabilities Act certainly has some sort of allegations relating to bathrooms. It might be, are the stalls big enough for a wheelchair to rotate? Is the door width wide enough to get in? Is the door heavy enough or light enough when it slams shut? Some of the other big issues are handrails provided? And usually an employer does have handrails, but are they the exact proper length? I've seen so many circumstances where an employer has told me, oh, we had an accessibility consultant come in and help build our accessible bathroom. And you know what? It's almost always still not it doesn't completely meet the specifications. And what I do a lot, as I mentioned way in the beginning, is I go, and my team goes to public accommodations, goes to our clients and inspects these issues and sees what is or what is not complying with the law, because unfortunately under the ADA, if your toilet is 1 inch closer to the wall than it's supposed to be, technically, let's just say, for example, the middle of the toilet is supposed to be between 17 and 19 inches from the sidewall. If it's 20 inches from the sidewall, you're in violation of the ADA, and then it's open season for your entire facility to be examined and everything measured and see what is or is not compliant with the ADA in your entire store or your entire place of public accommodation, not just the toilet and not just the bathroom. And then what happens is these lawsuits, at first glance, you say, oh, it's just injunctive relief you have to fix. But people don't realize sometimes how expensive some of these issues are to fix. Renovating an entire bathroom to comply with ADA standards can be quite expensive. And as I said earlier, that can lead to renovations at the rest of your company. Also, attorneys spend a lot of money going over the precise measurements, and we all are expensive. And as a company on the hook for these, you'll have to pay both your own legal fees and the plaintiff's legal fees. And some state law also provides for individual damages. So these are issues you just really want to be aware of. You know, I know you're not going to know right away the specific measurements that you need right now, but you want to have someone come look at your sinks, look at your counters, look at your handrails, and just make sure that that you are complying with the ADA accessibility requirements, so that your bathroom doesn't all of a sudden lead you to a whole host of liability issues that you were trying to avoid by making it accessible in the first place. And and the final thing, back to the transgender issue, is, and Eric mentioned this a little bit, what a lot of states are requiring, and this isn't a federal law yet, but I believe New York City actually has a requirement that there is a transgender neutral sign where there is also, the traditional disability sign. So it's not just limited to a traditional male and female, that also a transgender individual knows that he or she is able to use that bathroom.
All right, so just a couple more points, and hang out right here, because we've spent about an hour talking through a lot of what we talked about is this transgender bathroom issue. And what we've been talking about is kind of the lay of the land, the landscape of the law right now. And right now we are, a few days away from the end of the Obama administration, where this has been an agenda item for the Obama administration to advance this cause. The new administration, the Trump administration, will be will take the keys and take over these various agencies that advance issues of workplace safety and health, and advance issues of equal employment and public accommodation, accessibility. And I think it's pretty plain that they take a different view of this issue. Trump has said a little bit about it. Mike Pence has said a lot more about it. I think we know his views on these issues. Indiana, where he was the governor, was one that one of the states that advanced a law, like North Carolina, that was very much the opposite of what OSHA and EEOC and the Department of Labor under Obama had been trying to advance. So the real question, I think that we all have to think about is, what is this going to look like a month from now, or 6 months from now, or a year from now? And I can tell you from my perspective, I think it is extremely unlikely that federal OSHA is going to be enforcing this issue, that federal OSHA is going to be citing employers or bringing retaliation complaints on behalf of employees for a lack of accessibility to a unisex bathroom, or for requiring a transgender employee to use some bathroom on a different floor at the end of the hall. That is what the law is right now. OSHA has expressed it. It's their clear interpretation. But we know from the mortgage bankers, the Perez v. Mortgage Bankers Supreme Court case, that OSHA can change the law, and any executive agency can change the law by interpretation in many circumstances without having to go through rulemaking. And OSHA basically, through this guidance document, has said, we interpret the sanitation and bathroom accessibility requirements to include a requirement to make available a transgender bathroom. So that's what the law is right now. But that transgender bathroom guidance document from OSHA can be archived, and I think it almost certainly will be archived at some point in the Trump administration. I doubt that it is a high priority item that's going to get addressed in the first 100 days, or maybe even in the first year of the Trump administration, but I'd be surprised if that memo is still an active memo, is still OSHA's active interpretation in 2018, in which case, we could give a different presentation on what the law requires in this area, and I'm certainly interested to hear Jordan's perspective of what might happen from a Title VII standpoint, EEOC standpoint, ADA standpoint on these issues as well.
Well, yeah, it certainly is interesting. And as I mentioned, it could really dovetail to two ways. There's this case out there now, the Grimm versus Gloucester Board of Education, and in a few months when that's decided, I mean that'll be the law, at least for that employers will have to follow in terms of private plaintiffs. And the DOL and the EEOC, whatever they do won't change the law depending on how the Supreme Court rules. But the big thing is that the DOL and EEOC, and the new DOL, the secretary was just named the other day.
Nominated.
And not nominated. It likely will be named. And they are not going to be as investigatory heavy, enforcement heavy. This isn't going to be high on whatever agenda they have.
Right.
And most of this is pushed by these federal agencies. The EEOC is a little less clear. They've been so consistent the last few years on this issue. Obviously now the makeup will change, but I'm not sure. I unlike maybe OSHA, I'm not sure the EEOC will just do a 180 on this. It really, or maybe they'll back off a little bit, and it'll really become such a state-heavy issue. And depending on what state you're in, is really how you operate. Like I said, New York City has that new law that is as different as it can be from North Carolina's law. So, so it'll be interesting to see, certainly.
Yeah, so we've got a couple questions, and I'll address those in just a moment. I just do want to bring to your attention the terrific blogs that we have here at Conn Maciel Carey, the OSHA Defense Report, OSHADefenseReport.com, and the Employer Defense Report, EmployerDefenseReport.com, where we have all sorts of great written resources on issues like this and other breaking OSHA and employment and labor law issues. I would encourage you and plead with you to go check out these blogs. It would be wonderful if someone other than my mother was out there reading it, so please do that. And let's address a couple more questions that we have. And I encourage you, if you have any other questions, type them into the chat function here on the webinar platform, or, of course, feel free to reach out to Jordan or me or anybody else at Conn Maciel, and we're happy to address your questions. There is a really good question here that if showers are for post-shift time, then this time is unpaid, correct? And my answer to that is probably, I think that is not correct. In the circumstances that we're talking about, or that I was talking about today, where there is a OSHA regulatory requirement to provide a shower facility and to require employers to shower and essentially decontaminate themselves from the chemicals that they may have been exposed to during the work shift, as a regulatory requirement, I'm fairly confident that makes it a compensable activity under the FLSA. Donning and doffing is a tough, heavily disputed and heavily litigated question, but generally the way those cases come out is that if donning and doffing is considered a principal activity, then it is compensable time under the FLSA. And where donning and doffing of work clothes and showering for decontamination, it's part of that donning and doffing process. Where it is required by law, or where it is required by the employer, or where it is required by the nature of the work, it is considered indispensable and integral to the work activity. And since in the context we're talking about today, OSHA's chemical-specific standards for lead exposure, asbestos exposure, whatever, mandate that the employee leave their contaminated clothing, go into a shower facility, shower, and then go into a clean room to put on street clothes. Because that is a regulatory requirement, I believe it would be compensable under the FLSA. And Jordan is much more of an expert on that topic. Do you think I got that one about right?
Yeah, I think so. I mean, these are all sorts of issues that we get all the time about, is the changing time required? You have some uniforms that you have to change out of, and that technically isn't, because you can leave and still be wearing your clothes. It's different if you're wearing protective equipment. And, a lot of that stuff you were saying just went over my head because we started talking about contamination.
Right. I mean, basically, the law says, employee, thou shalt not, and employer, thou shalt not allow employees to take this work clothes home with them, because you could potentially be taking contaminated chemical, hazardous chemicals home into your home, and so you're required to change out of them.
So by being
required,
it's part of your job, essentially.
Right.
And you'd want to err on the side of caution and pay someone for a job requirement. Again, that's a little different than working, let's say, at a restaurant and wanting to change out of your hostess uniform. That typically is not considered compensable under the FLSA.
Right. One other really good question here I see is that if a unisex single stall bathroom is readily available in the workplace and it is usable by any employee, including a transgender employee, and certain other employees have objected to or expressed discomfort with a transgender employee using the men's or women's room, would it be considered a violation by OSHA of the sanitation standard, accessibility standard, or whatever, if the employer required the transgender employee to use the unisex stall and said, it's available to anybody, and even if you would prefer to use the ladies' room because that's the gender you identify with, we are requesting or requiring that you use the unisex bathroom. Again, these are not black and white issues, and I think when you think about it in the context of some of the cases that Jordan just outlined, where basically the courts, and this is OSHA cases can end up out in the courts, in the federal courts, and to the Supreme Court, if it ended up that way, are taking the position that employees, the public, people in this protected class should be permitted to use the bathroom for which they identify themselves. And if they are more comfortable, and I think it's maybe even more clear-cut in the OSHA context because of the way OSHA casts this as a health issue, they're saying if you are not comfortable with the bathroom arrangement that is available to you, then you will be inclined to not use the bathroom at all, to hold it until you get home, or to feel marginalized, or to not feel safe. Then that's effectively not providing a bathroom at all. And therefore, there's a health risk associated with that. So I think OSHA would cite that issue. It seems to me like the federal courts are erring right now on the side of the worker or the person in the public who would prefer to use the bathroom of the gender for which they identify. So I think it would be a problem under the current OSHA landscape. I think it's almost certainly not going to be a problem 8 months from now when a new OSHA administrator is in place and this policy has been revisited. But right now, under the law, that's how I think that would be handled.
Yeah, and from my perspective, as an employment perspective, I think a court would look at it that a quote-unquote traditional male could use either the men's restroom or the unisex one, and now you're telling the transgender he's only allowed to use the unisex one. And that's really not fair to the transgender individual, and they really couldn't really care less about whether other employees are uncomfortable or not. That just does an other employee preference doesn't really come into the equation at all, at least on December 13th, 2016.
Yeah. So I'm not seeing any other questions right now. If you do have other questions, here's Jordan's and my contact information. Don't hesitate to reach out. Hopefully we accomplished today what we set out to accomplish, and that is to wade into an incredibly controversial, incredibly hot issue and do it in just sort of a fact-specific way, a legal analysis that is not controversial. I mean, other than the fact that we all have different views of what the law ought to be, hopefully we accomplished providing a fair presentation today of what the law is, regardless of what we think of it. And I enjoyed this discussion probably as much as any other topic we covered this year. And so as we formulate the 2017 OSHA webinar series, maybe it'll just be 12 months of talk about bathrooms, or maybe we'll find some other interesting OSHA topics. But please look out. We are intending to circulate a copy of the slides that we used and a link to the recording of the webinar. And very soon, probably within the next week or so, we'll also be pushing out an announcement about the 2017 OSHA webinar series. I really, as much as hard work as it was, to come up with fresh topics, to research these topics, and to put on a presentation each month. I enjoyed it very much. I enjoyed the interaction with you all and the feedback we've gotten. So we will be doing this again. In about a week, we're going to announce the topics. And I hope that you can all join us for another year of very interesting discussions. And of course, as always, write to us, tell us or call us and tell us if there's a topic that you think we ought to be covering in this series. Let us know, and we will we'll find a way to work it into the program. We really enjoy this. It's for you, and we want your feedback. So this has been a lot of fun. Happy New Year, happy holidays to everybody, and we look forward to will likely be an incredibly interesting 2017 with the new administration. So thanks, and have a great rest of the year.